Okay, I'll call the House Rules Committee to order. And the first thing on the agenda is approval of the minutes of April 25th, 2023.
Second.
All those in favor? Or
Aye.
those opposed? The ayes have it. The second issue is the deadlines. I believe you all have a copy of the deadlines in front of you. Make a motion to approve them, or? So moved. Second. Discussion. Senator Weber.
Thank you, Mr. Speaker. I just wanted to raise for discussion. I'm always the person who is trying to get more time for the House to deal with the House's bills because we have so many. And I have sort of my usual concern about the short time period to report the House bills going to a second committee, because that's just January 5th to the 15th. And often the bills, my usual concern about that is that the bills that are the biggest, most complicated, and need to go to two committees often come out late. I assume that's not going to be an issue this time because we don't have a November drafting period. So I assume that we would have all the bills in hand that first week in January. But the other thing I was thinking that we could pick up a little more time, even if we didn't want to move that one week later, is the issues of the last day to report a House bill not in the second committee, which is the huge bulk of our work. That could be moved to March 21st, with the last day to act moved to March 28th to give us a little more time to work on that without destroying anything else, because the second committee bills will all be on their way. So I just wanted to put that out because I know that we will get to the point next term where, we literally this last year had about 2 weeks to get some of the second committee bills out, which was really of concern because there wasn't time for the first committee to do a thorough review. So I would move all four of those first deadlines, February 25th, 22nd, 14th, and 21st, 1 week later, but particularly the second committee ones, which are the ones not going to a second committee, which is the bulk of our work.
Mr. Clerk?
Thank you, Mr. Speaker. So the difference in the first year and the second year is that all bills have to be introduced by the 5th of January. So that leaves 6 weeks for all of the early bills, which is substantially more than in the first year. And I noted that from your comments in the minutes, and that's why we have expanded to 6 weeks for the early
Okay.
bills.
Well, and I did note that. So
But
thank
yes,
you.
That is a substantial difference between the first year and the second year, is that the last day to introduce House bills is the 5th before giving the full week, giving the next full week of the week to start a full 6 weeks of work. Regarding the second committee, the not in the second committee, those are certainly doable dates. It's just a matter of preference. If you'd like to extend that, we can certainly do that.
Sorry, I wasn't on the mic, sir.
Okay. Anybody else? Senator Smith?
So if I understood correctly, the proposal is 14th becomes the 21st, 21st becomes the 28th? Question for the clerk, does that jam us up on anything that comes after?
I don't think so, sir. The issue is that the following week is the reporting of the early bills, the remaining House bills. So I don't see that that's an issue. I would suggest that although that becomes a session day for sure, that shouldn't prohibit us from meeting in session on the week prior. As you all know, we have been doing more and more bills on fewer session days. And I'm sure that your families and your dogs probably don't like you being away as long as you have been on those session days. I do think that we need to be more timely in the work coming out of the committees in order to have more session days, even if we do Thursday afternoons rather than a full day. If we have 25 bills that we should try to take up as much in session as we can to mitigate, a 3-day 600 bill calendar. So that's just a little personal aside.
So if I'm correct, we're going to move, we're going to add the 28th. Is it the 28th?
If you were ready for a motion, I would move that we change the deadline, which is March 14th, for the last day to report House bills not in a second committee, to March 21st, and then move the March 28th deadline, current March 21st deadline to the 28th. But I would say that I do agree with the clerk that that does require some management of chairs and committees to get stuff out. Time was before COVID that we normally had a session every single week on Thursday or Wednesday or whichever day it was. And chairs, no matter who was in charge, were urged to get the bills out so that those could get moved along. But, it's up to the collective wisdom here. I don't think it's going to make a huge difference either way, but it was just something I thought about.
I'd second the motion.
Okay. Are you just moving those 2 dates, or are you moving the whole, just those 2 dates? Okay, so we'll take up that, and we'll take up the full calendar. Okay. All those in favor? Okay. So now we need a motion to accept the House rules. You already have that. Okay, the motion before us, is there any discussion on anything else on House rules? If not, all those in favor of adopting House rules? Oh, you need to do a roll call? Clerk will do a roll call.
Representative Packard,
Yes.
Representative Shirtliff,
Yes.
Representative Smith,
Yes.
Representative Nodder,
Yes.
Representative Osborne.
Yeah.
Representative Sweeney,
Yes.
Representative Wilhelm. Yes. Representative Weber,
Yes.
Representative Simpson.
Yes.
Motion is adopted 9-0.
Okay, the next thing is the late drafting and introduction of bills. And the first one on the list is Representative Davis.
Thank you, Mr. Speaker, and thank you to all members of the Rules Committee for allowing us to come in and make this request today. The reason for our late filing, we've had meetings with new owners of property in Coos County, and learned information that we didn't have before. It's potentially a large negative impact to Coas County and possibly the rest of the state, is pertaining to timber taxes. So I don't know, how much information you need, but that's the reason.
Basically, we don't want too much information. We just need to know why the
Okay.
the late filing, you're asking for the late filing.
Yes, we've learned new information.
Say something?
Yeah.
Thank you, Mr. Speaker. We're talking about the Headwaters property in Pittsburgh to start with. It's 140,000 acres. And it'll have as Representative Davis said, a true impact to start with in Coas County, but it'll be statewide to do with timber tax, recreation, and really our culture. So we need a little more time. We've had meetings with them over the last couple weeks since the filing deadline, and we really feel this is imperative to continue on.
Representative Weber?
Actually, Mr. Speaker, I think you just answered my question. What I was going to ask was the timing of when you learned new information about this situation, and you said you had discussions over the last couple of weeks. Is that correct?
That is correct. We've had Representative Davis, myself, had some private meetings with the new landowners, and there was a public meeting about 10 days ago. And every time we meet with them, there's new information coming out.
Any other questions? Representative Osborne?
Thank you. If you're still in the process of gathering new information, are you even ready to file a bill at this time?
I believe so. We've been looking into it. We weren't ready to put in a bill, but in light of new information I think something needs to be done fairly soon.
Further question?
Thank you. And so you'd say that this is an emergency situation that cannot wait until next year?
I believe so.
Also, this is not a partisan piece of legislation. The whole county delegation is involved with this and of all the same point of view.
Okay, any other questions? Move approval of the late filing. Okay. We have a first and a second. Any further discussion? You got to call the roll on this, Mr. Clerk? Clerk will call the roll.
The motion is for late drafting for Representative Davis. Representative Packard.
Yes?
Representative Shertliff.
Yes.
Representative Smith.
Yes.
Representative Nodder.
Yes.
Representative Osborne. Representative Sweeney.
Yes.
Representative Wilhelm.
Yes.
Representative Weber.
Yes.
Representative Simpson.
Yes.
Motion is adopted 9-0.
Chair recognizes Representative McGuire.
Thank you, Mr. Speaker. My request is to be allowed to violate House Rule 36E, which is the one that prevents you, if a bill has been retained or otherwise considered in the first year, to allow it to be resubmitted in the second year. And the bill in question was my own bill, House Bill 593. I brought a copy in case anybody wanted to look at it. Relative to the forfeiture of assets in connection with a drug offense, which has to do with RSA 318B:17B. And so what happened with this bill was that it was sent to the Criminal Justice Committee. It had its public, well, first of all, we created the bill, and I did extensive work with the Attorney General's office. We met with the representative of the judiciary. Representative Lynn helped me draft it, et cetera. and also outside groups. It's of interest to the ACLU, the AFP, Institute for Justice, and so on. So we did all that, and we thought we had sort of agreement among all those parties. But what we discovered in the public hearing was the judiciary in particular was not on board with this bill. And so partly because of that, and partly because this is a complex bill, it was retained by the Criminal Justice Committee. And so over the summer, we met with the Chief Justice and with members of his staff and discovered what the problem was with them had to do with the way the bill didn't comport with their computer system. And had the bill passed in its original form, it would have required them to spend a lot of money on custom software. So we worked out a way to meet our policy goals, but not cause that problem, to be compliant with the way their software works. And so, that took a fair amount of time, and we worked out new language for the bill. And so I came to September when the retained bill committee, the committee was going to have its retained bill hearing, and I could have just sort of dumped a new 12-page amendment or something on them. But in the meantime, I had come up with the idea of splitting the bill into 3 pieces. Number 1, to make it slightly more manageable. Number 2, to make it more likely that certain pieces would pass, because there's objections to part of the bill, but not to the whole bill. There's a certain part of the bill, very small, that has considerable objections from law enforcement. But I don't think that applies to the bulk of the bill. And also there are different, the reason we originally had one bill was it all affects one RSA, this one section. But in reality, there's parts that are financial, there's parts that have to do with courtroom practice, and there's parts that have to do with state and federal relations. And so it really, in my mind, would be correct to have it as 3 pieces and not as one big piece. And it would enhance the we have to think not just of passing the House, but of, passing and being enacted into law. And I think it would enhance at least some part of the bill becoming law. So, and then the reason for, so that's my request. So I asked the Criminal Justice Committee, please find this bill interim study. And this was my plan, and they agreed that that was appropriate. And so I think that's what's going to happen to House Bill 593. It's going to be interim study. And then the question of, well, why not just wait another year? Well, this bill involves justice, right? This bill involves, it's not a lot of people, a lot of accused and so on, but it's some. And so, there's no reason to wait for justice to be done, basically. Thank you.
Representative Weber?
I'm a little concerned about the fact that a lot of this seems to be the result of choices that were made with respect to an existing bill. And a lot of what you're arguing to us is that it would be inappropriate to bring in something large and cumbersome without benefit of another hearing. And I agree with you entirely on that, but there's no reason why you couldn't have another hearing now and get public input, particularly on amendment that would have the pieces that you think are particularly appropriate to go forward. But the rest of it sounds to me like stuff that's been under consideration for a very long time and is a matter of tactics.
Yes, thank you for the question, Representative. When you say, I guess I'm not quite sure, when you say we could have another public hearing now, do you mean the subcommittee of criminal justice that's dealing with this bill could create a new public hearing, et cetera. Yes.
If I may clarify, it could either be a subcommittee or it could be a working session of the full committee. And all you have to do is notice that amendment with reference to it in the calendar. So that's perfectly doable, and I think it's a laudable goal that could be done within the existing framework.
Yes, thank you. Okay, that is possible. The other aspects of it in terms of timing are that we worked extensively with a member of the AG's office who has since left the AG and went into private practice. And so I would kind of like a little bit of time to circle back with them and get new input on our changes prior to showing them to the legislature. And so the timing doesn't quite work for that, in my opinion. And also, I'm enthusiastic about breaking up the bill because I think that make it easier both on the legislature and on the members of the public who are interested in certain parts, but not the whole thing.
Shirley? Thank you, Mr. Chairman. Thank you, Representative. Just so I'm clear in my own mind, has the full committee met to vote up or down on this bill?
As far as I know, no.
Follow up, further question. Wouldn't it make more sense to go to that committee when they do take it up for their final disposition of the bill, to ask them to, with the recommendations you're going to make, to allow it to go forward?
Yeah, thank you. But again, I think the changes are more substantial than the committee would want to consider over this short period of time. That's the issue. So in my opinion, it's too rushed because they're going to have to make a decision within a few weeks.
Representative Smith?
Two questions, if that's allowed. Have they already exec 593 or not?
The subcommittee has, with my recommendation of interim study, and it was unanimous. But the full committee has not.
Thank you. Follow up.
Further question?
So the three bills you're proposing, are they drafted already?
Yes, I have them here.
Okay. Through OLS.
No.
So you also want late drafting and introduction?
Yes, I asked when I asked to be on your agenda was during the week of where we were submitting bills, and I asked, should I go to OLS and have them say to me, well, you can't pass, these are the same as your other previous bill, and I was told no, that there was no particular reason to do that.
Further questions? Osborne?
Yeah, I mean, I was just going to get in on the same topic here. If these changes are so significant, I was just wondering why they weren't filed during normal.
Okay. In my opinion, they violate House Rule 36E. Okay, the subject of the bill, a lot of the contents of the bill are the same as House Bill 593. Two of the small pieces that I want to break off are the same. They're not changed. The structure of the bulk of the bill is somewhat changed, but I mean, I can get into the details, but if you really want, but basically, what happens now in law is that the asset forfeiture case is a civil case, and there's an underlying drug offense criminal case. All right, House Bill 593 combines those into one single criminal case. That's what caused problems for the judiciary's computer system, was having these two kinds of things be under one case. So our new approach that we are doing with them keeps them split, but has a lot of timing aspects that merges how they proceed. And so, you know, in my opinion, it's, you know, this is all the same subject, right? I mean, and so, in my opinion, it does violate House Bill 36E, and in my opinion, that's what, you know, that's why I'm here.
Further discussion?
And Representative Lynn came to, you know, support this request. I don't know if you would like to hear from him or not.
Speaker? It's helpful to have some idea what we're talking about, but I'm going to remind everybody that we only discuss the reasons for the late drafting or the difference, you know, the departure for the rules. We don't delve into the underlying
I
context.
understand.
Representative Smith?
And if I understand correctly, you believed that you weren't going to be able to get these submitted until you came to our next meeting.
Yes, well, I had experience with OLS turning down a request for an LSR on the basis of similarity with a previous bill. And in my opinion, those two were not at all similar. And so in this case, I was certain that they were going to find these similar, right? So.
Follow up?
Follow up.
Trying to help. So you need the late drafting because you wanted to come here first because you believed that there was going to be an issue and just wanted the ruling body to deal with it.
Yes.
Thank you.
Senator Weber?
But I am clear that you did not, in the first instance, go to OLS and ask them if they would do that drafting or argue with them, as any number of people have done this term and other terms, about whether their decision was appropriate or not.
I certainly did that in the case of my other bill. Not with this bill, no, because again, in my mind, this one is much clearer compared to the others.
Senator Sherlin, would a motion be in order? I'd move that we not grant the permission to file a late bill. If I could just speak briefly to the motion, with all due respect to my friend from Epsom, I hate to set the precedent in this body that we're allowing somebody to file a new bill while the standing committee still has possession of the old bill and hasn't adjudicated it or acted on it. And secondly, as a member from Cheshire County said, I'd rather see it go back to OLS and file 3 separate bills and let OLS and eventually maybe the speaker make a decision if there's enough changes to have it go forward. Thank you, Mr. Speaker. Further discussion?
I would just second for discussion the motion of my friend from Pennacook.
Any further discussion?
I just wanted to point out a further inconsistency. I mean, one of the concerns that was raised was this is a matter of justice and they don't want to wait until next year because it's a matter of justice. But but they're also arguing that they don't want to do it quickly. So I think that gets us in a bit of a bind, and I really think it's an awful precedent for this body to set. Thank you.
If there's no further discussion, clerk will call a roll.
Thank you, Mr. Chairman. The motion is to deny the request. Representative Packard,
Yes.
Representative Shirtliff,
Yes.
Representative Smith,
No.
Representative Nodder,
No.
Representative Osborne, Representative Sweeney? Representative Wilhelm?
Yes.
Representative, excuse me, Representative Weber? Representative Simpson?
Yes.
Thank you.
6-3, the motion passes.
Chair recognizes Representative Luno.
Thank you very much, Mr. Speaker, members of the committee. For the record, my name is Dave Luno, representing the people of Merrimack County District 9, which folks live in Hopkinton and Bow. I'm here this afternoon to ask the committee to approve the late filing of a bill with the same language as House Bill 626 from this past 2023 session due to circumstances unforeseen prior to the close of the filing period. My remarks this afternoon are intended to lay out the facts and the justification behind this request. For background, House Bill 626, for the most part, shifts administration of the Education Freedom Account program from a third party to the Department of Education. According to the bill's docket, House Bill 626 was introduced in the 2023 session and was referred to the Education Committee. On February 14th, 2023, it came to the House floor with no recommendation and was voted ought to pass 183 to 180 and referred to the Finance Committee. Then on April 6, 2023, the bill came back from the Finance Committee, and on the House floor, a motion of ITL was adopted on a roll call vote of 195 to 194, with the chair, Speaker Packard, participating by voting yes on the ITL motion. Leading up to the LSR filing period, September 11th through 15th, 2023, I had conversations with the ranking member on education and Leader Wilhelm, and was advised that I could not refile this bill for the 2024 session because House rules bar introduction of legislation in the second year of a session that was voted ITL in the first year. And that's where we thought the story ended. But on September 18th, 2023, 3 days after closing of the LSR filing period, the Speaker's office received a letter from the Attorney General concluding that House member and State Representative Troy Murner was not domiciled in the district that he was elected to represent at any time during the 2023 session in violation of state statute and the New Hampshire Constitution. So let's go back to the disposition of House Bill 626. The ITL vote back in April was a roll call vote, and Representative Murner participated in it, voting yes to the ITL motion. Based on the Attorney General's investigation, it's clear that Rep. Murner's vote was illegitimate, and without Murner's vote, the motion of ITL would have failed. I'm here today to ask the committee to allow for the late filing of an LSR with the same language as House Bill 626 that we're talking about, with the effective date adjusted by 1 year. House rules permit this committee to approve the late filing and introduction of legislation, quote, based on urgent or compelling need or events unforeseen prior to the filing deadline. And it was not known that the disposition of HB 626 was illegitimate until after the close of the filing period. Upon examination of the House's votes from this year, there were likely many motions in which Rep. Murner's vote affected the outcome. But in the case of House Bill 626, a roll call vote shows that Rep. Murner specifically enabled an ITL motion to be adopted. This is an important bill to many members of the House, as its multiple strong votes indicate. Had it been laid on the table or otherwise stalled but not found ITL, it would have been refiled for this year. Clearly, this is an event unforeseen, as the House did not know until the LSR filing period was over that the disposition of House Bill 626's ITL was not legitimate and should not have barred its filing for the 2024 session. I ask the Rules Committee to support the request for late filing so that we can rectify the harm caused by Rep. Murner's vote. Thank you.
Questions for Senator Bruno? Okay. If there being no questions, I'd make a motion. Okay. I would move to allow for the late filing. If I could speak briefly to the motion. After the second comes, thank you for finishing my sentence.
I'll second it.
Mr. Chairman, first of all, I consider still today Troy Marner, I think a lot of us in this room do, as a good friend, regardless of whatever happens to him in the future. But I think on this instance, where this was a tie vote on the motion to ITL, and his being not a resident of his district, and if you can believe half of what you read in the paper is the comments made that he knew full well that he wasn't supposed to vote, that he was not living in Lancaster. I do find that somewhat egregious, very much so. And I think he had an impact on the outcome of this vote. And I would think under those circumstances, where the House was so evenly divided on this question, that to allow the member to file again under these circumstances would be the appropriate thing and in the best interest of the House tradition of fairness and right doing in all circumstances. So thank you, Mr. Speaker. Further discussion? Senator Smith?
Thank you, Mr. Speaker. So, one that we think we know about, I don't know when Representative Murna stopped using the apartment in Lancaster. I don't know when Representative Hatch moved to Bedford a couple of years ago. I don't know when a representative who moved out and then got elected in a new district left. They didn't resign in the middle. They were serving, I'll use the word that's been brought up, illegitimately, unless they moved on organization day. We hear rumors about these things all the time. So if I can find one other representative serving illegitimately, do we then come back to this body and undo this vote? I don't like the cycle of getting into that and going back to try to find ways to redo votes. Not the way we should do it.
Further discussion? Senator Sherwood? Far be it for me to disagree with my friend from Charlestown, but in this instance, I disagree with my friend from Charlestown. I think we do know from what the Attorney General has told, but even more, we know from the comments made by Representative Murner and the Union Leader and other newspapers, the fact that he knew for 6 months that he was no longer living at his residence. The AG said in their report that he had moved out of Lancaster, the apartment building he just had an office there, but he was living in Carroll in Coas County. And that he'd been out of that district for quite some time. As far as my friend Bill Hatch, I know we all know, we miss his service in this House and on the Finance Committee. We know he has been ill for quite some time. Of course, he's been out of the district. He was in Connecticut for a while because of his illness. And knowing Bill, I know he's a man of ethics and would not do anything inappropriate or contrary to the rules of this body. But I think as far as Mr. Murner, Representative Murner, as I've said, he stated in the press that he was out of his district for 6 months, but the fact he mentioned that other members of the House have done the same thing. And I think all of us in this room know that members of the House have not done that same thing, that we take pride in representing our districts, and we've had members resign because they moved one town over. So with all good faith and my friend from Charleston, I disagree with the comment. Thank you, Mr. Speaker. Senator Weber?
Thank you. And following on from the comments of my friend from Pennacook, this is an extraordinary set of facts in this case. And the issues of residence and domicile are difficult and murky. I know we had a member, for example, whose house burned down, and he could not therefore live in the house that was not there anymore. And during the course of rebuilding the house, he stayed in a place that might not have been in his district, but his intent was always to return. So, and intent is a legal portion of the inquiry. This case is particularly clear in that the representative himself made certain allegations, certain representations at certain times that made things much clearer than they are when somebody is trying to deal with a difficult situation. We've always taken these matters one at a time and looked at the individual facts. And I think we have in the past made real accommodations for people who were dealing with difficulties of one sort or another. The other distinguishing factor, of course, is that Representative Hatch was not here to vote on anything. So there's not, when he had already, when he stated that he had already, when he later stated that he had already moved. So I think these should be taken one at a time. I agree that they should not set a precedent for every single thing, but I think that we have, the issue is looking at each case individually, and this case is far more clear than many of the other cases that we have seen. Thank you.
Representative Smith?
So, other things that I know happened recently, not this term, a representative elected rolling around New Hampshire for over a year without a state plates because they had just moved here. So I would just ask you to ask yourselves, do you believe they were serving improperly because they were a resident of another state? Or do you believe that they were willfully violating our motor vehicle laws? Because those are the only two options. There's a lot to look into in these. I agree with you. But let's go back to the procedure part of it. Can this not be filed for 2025? Is it that urgent? Is there no bill sitting around that an amendment could go on? With a little artful authoring, it's usually possible to get what you want out of a bill tagged onto another one. There must be some other way to accomplish it than for the Rules Committee to do this, essentially saying publicly that we're undoing a vote on the House floor, which I'm not going to vote for.
Further discussion? Okay, the motion before us is to accept the late filing. Clerk will call the roll.
Representative Packard,
No.
Representative Shirtliff,
Yes.
Representative Smith,
No.
Representative Nodder,
No.
Representative Osborne, Representative Sweeney,
No.
Representative Wilhelm,
Yes.
Representative Weber,
Yes?
Representative Simpson.
Yes.
Motion fails 4-5.
Chair recognizes Representative Weber.
Thank you, Mr. Speaker. For the record, my name is Lucy Weber. I represent Cheshire 5, which is the Connecticut River towns of Walpole and Surrey. I have to think a little hard. I've represented 11 Cheshire County towns over the course of my service here. So what I want to ask for the permission to draft out untimely also arises out of the issues surrounding the Attorney General's letter that was received by the Speaker on September 18th. In that letter, what I would like to do is draft a bill, so you know where I'm going with this, that would require the Attorney General to notify the House as soon as they get some kind of confirmation that a member may be sitting who is not residing in the district where they're supposed to be. And I know that this has been raised. The problem was that Representative Murner made representations to the Attorney General's office in May, and the letter did not come to the Speaker until September, during which time many votes were taken, which we all now view with certain degrees of problematicality. Anyway, what I am proposing, the Attorney General, when people said, why did you wait so long? The Attorney General responded that their office did not want to compromise a criminal investigation. And if you recall the letter from September 18th, there was a significant amount that had to do with the membership in the House, which the Attorney General acknowledged was a matter for us to consider. But there was also a significant amount of that letter that had to do with their criminal investigation and where it had arrived. And what I want to do is to try and separate out very clearly those two issues for the Attorney General's office, should this bizarre situation arise again. And what I would like to do is be able to draft a bill that requires the Attorney General's office and the actual wording of the bill can be entirely up in the air until it goes to a committee and is discussed thoroughly. But I want this body to be notified as soon as there is a determination or possibly just credible evidence, and again, that's to be discussed later on, about knowledge that the Attorney General has about somebody's residing elsewhere other than where they were elected from. And I want to separate it out very narrowly because I want to make it very clear that the only thing we are asking to be informed of is the residence issue, which is only for this House to decide. And any issues other than that may lead to a criminal investigation would be well outside of anything that the Attorney General is required to convey to us. We certainly would respect their part of the process, just as I think they should respect our part of the process. So that's my proposal for late drafting. Again, it all arose after the drafting period, and I would hope that what we would have is an opportunity for the House to take a good look at this situation in a public forum, and for the Attorney General also in a public forum to have the opportunity to discuss with us the concerns that they have, so that we could come up with some clear and meaningful legislation going forward as guidance as to whose responsibilities are which in this issue that is so entangled with issues of separation of powers. So thank you for your consideration.
Representative Smith?
Thank you. So I'm confused about what it would actually do. So allow me a hypothetical, and this is not based on any actual person. So a serving representative who, based on his tan and social media posts, appears to live in Florida. I'm sorry if that resembles anyone. So I put in a request to the Attorney General to see if this well-tanned and fun-loving individual is actually living in Florida 80% of the time or is a New Hampshire resident. What happens next?
Well, my understanding of residence, which dates from law school, which I attended in the late Stone Age, because I have avoided sitting on the election law committee, has an aspect of intent. And it's going to be an individual inquiry in every single case. But I think this is one of the things that ought to be discussed thoroughly in committee as to whether the Attorney General has a responsibility to report to us only when they have confirmed that the individual is not living in their district, or whether they need to report to us when there are concerns. In your hypothetical, if there's stuff all over the internet that could give rise to an inquiry, I think there's all kinds of aspects. We certainly had a case of a representative whose reputed not to be living in his district. And that was sent to the Legislative Administration Committee, which I believe actually voted to recommend to the full House that he be removed from the House. And that recommendation should have been taken up at the next House session, but because that member presented to the then Speaker a signed lease, that the then Speaker decided that that was moot. And I think that that's an incorrect decision, because I don't think it's not a matter of whether you get tagged off base. The Constitution doesn't give you a right to cure. The Constitution says when you leave, the seat is vacated. And so my argument in that case would be, if they don't have the backup, they don't have the backup, and whatever you're postulating is also available to everybody. I certainly didn't have any way of knowing where the representative was living or what his living situation was. And I think that's something that ought to have been communicated to the House. And I think that anytime we have that concern, the House can take it up as a matter of its own responsibility and has the duty to do that. Because I think that is our duty, to make inquiry into those situations. But again, this is a very specific situation. And I think it would be helpful to have a clearer delineation of what the responsibilities are. And as I said, I would draft a bill with some selections that I might make, but I would offer that entirely in the spirit of having the House thoughtfully and carefully deliberate with input from everybody involved as to what the best way of dealing with this kind of situation should it arise again.
Senator Sherwood? Thank you, Mr. Speaker. As I understand what you said, what your bill would do would require the Attorney General, once they realize that a member of the House is living somewhere other than their district, to notify the Speaker, notify the House?
That's correct.
Do have a concern with that, and we know that members of the House get in trouble, and I think our friend from Wyndham sitting behind you was in the U.S. Attorney's Office when the Majority Leader from the New Hampshire House was arrested on federal charges. If that had been a state well, I'm not going to mention the name, but it's on the plaque out in the hall if you want to look at it on your way out. If that had been a state investigation and they were investigating him on some of the criminal offense and realized that he was living somewhere else in the state or somewhere else altogether, maybe Florida, under this law, they'd be required to notify the House that the person was no longer living in the district, and therefore jeopardizing their case by notifying their target that they were investigating them, because that's how the information got to the New Hampshire House.
Well, in the first place, the bill that I was contemplating only spoke to the Attorney General's office, not to federal
I'm speaking
authorities.
to the Attorney General's
But
office.
oh, well, you spoke of a federal investigation, and I'm not familiar with
As
it.
an example of,
But I think that there isn't a need to compromise a criminal investigation, because the only thing that needs to be communicated to the House is the fact of residents or non-residents, not anything else. And nobody has to discuss with the House why they were investigating that. It could have been a complaint filed by a constituent, such as the town clerk here. And the Attorney General's office could make it very clear that they were not going to discuss the source of the complaint. And I think perhaps it would be a very good suggestion for the bill that they not, under those circumstances, discuss the source of the complaint.
follow-up question. Instead of a piece of legislation, could not the Speaker's office enter into a memorandum of understanding with the Attorney General that we be notified when they feel at an appropriate time that the person has moved out of the district, if it comes to their attention, I could see where it could jeopardize a case. If all of a sudden the speaker is getting a letter from, the Attorney General saying, we know this person has left. And of course, that person will turn around and file a Freedom of Information Act, saying, where did you get this information possibly?
Well, I don't think that Freedom of Information Act necessarily is going to be successful because of certain exceptions, but this is why we don't go into this underlying specifics of the bill. And my point would be, I would like to have the bill introduced. And it may be that upon introduction and after a hearing and after discussion, it may be determined that there is no way to do that appropriately. But I think that the place to have that discussion is out in the open with all of the members of the New Hampshire House and the public being able to participate, and not in a closed memorandum between the Speaker and the Attorney General's office, because it is a matter that affects all of us as House members and all of the members of the public in terms of representation. So, as I say, I make no representations about whether I would even vote for the bill at the end of it. I may be persuaded that there is no way to draft such an issue. But I think it ought to be drafted, I think it ought to be discussed, and I think that ought to be done by this House as a way of keeping its House in order, rather than by a memorandum of one person to the Attorney General's office. So, as I say, I'm not taking a position on how we would come out on it ultimately. It may be that you're absolutely correct, that we would determine that the risks would be too great if there was a criminal investigation. But I think that's a decision that the full House ought to make. And that's why I'm asking that a bill be drafted.
Further discussion? Representative Osborne?
I was just going to make the motion to accept late drafting.
Okay, motion has been accepted. Further discussion? Senator Wilhelm?
Thank you, Mr. Speaker. I appreciate the motion here and am hopeful that this can be a bipartisan effort as we work its way through the committee process into the House floor. I think we know that we have a constitutional responsibility to make sure that our members meet the qualifications for office, and figuring out, what we can do moving forward to maintain the integrity of the institution would go a long way. Thanks.
Further discussion? Senator Naughter?
Thank you, Mr. Speaker. I was getting confused, and I'm trying to wrap my head around this, because when you first started talking, it sounded to me like you want people to be presumed guilty until they're proven innocent. But then you said it has to be investigated first, but that's what happened. I wrote down, you said something about May. They started investigating in May, and they came out with their letter in September, which is what happened. So I don't see the need for this right now, and I just don't feel comfortable voting for this.
Further discussion? Representative Osborne?
Yeah, so I am, I don't imagine that this bill is going to be able to go anywhere and be able to overcome the objections that the representative brought forward, but Representative Weber did very clearly indicate why this was, new information had come to light, and that there could be other circumstances that this would affect over the next year, and so it is timely, and it should be brought for discussion, in my opinion.
Further discussion? I will be honest, I'm conflicted, so. You want to pass? I'm really conflicted on this one. I get what you're asking for, Representative Weber. I'm just a little concerned that, going back to Representative Shirtliff's concerns, that once that letter came to us, which was between 4 and 4:30 in the afternoon on Monday, even though I was on the phone first thing in the morning telling Representative Representative Murner that he had to resign, that letter was out. You know, it was out there and all the information was in it. And that concerns me if there is further criminal investigation in the letter that, you know, was submitted to us. And that's why I'm so conflicted.
And may I answer that?
Yes.
Here's the thing. There was no necessity for 3.5 of those 4 pages. All the Attorney General needed to have said was, Mr. Speaker, we became aware on X date that this was a fact. And in that case, the representative had stated to the Attorney General where he was living. So it was not a near thing or a question of intent or anything else. He stated that it was his intention to finish out his term even though he didn't live there. And the Constitution says you can't do that. So the concerns that you expressed, one of the reasons that I want this drafted is to make it clear that the Attorney General need not put all of that into a letter. I mean, he did because he wanted to make a particular case to the House, and that was his decision, and that was perfectly fair. What I want to get at is the fact that you acted immediately after you received that letter, but the knowledge that he was not living in his district was available at a minimum in May, and you were not informed of it, and the House was not informed of it, so it was not available to be acted on. And as a result, a member who had stated that he was not living in his district had voted multiple times. And that's something I really want to avoid for us going forward. So all I'm trying to do is move the notification point, because you're absolutely right. Once that letter was out there, it was out there. But what I'm trying to do is both limit what is in the notification to simply the fact of where the representative is living and make sure that there isn't a lapse of 5 months while a whole investigation is going on, during which time somebody is voting without the authority of the Constitution, because the Constitution says that your representative ceases immediately. And so that time lag is one that is unconstitutional, because in this case, just in this case, it would be very different in any other case. The member was aware. He may not have been aware of the provisions of the Constitution, but the member was aware of where he was living and had a particular view on it. So the reason that I think we ought to have a bill to explore all of this is to explore how to appropriately limit, if that is possible, a notification, to whom that notification is sent, to the speaker in the minority and the majority leaders, to the Legislative Administration Committee, to the entire House. But I think those are things that I would love to see discussed in public to see if we can come to a reasoned conclusion that would satisfy and clarify for everybody, because this situation was allowed to persist for a long time with people knowing that something that was violating our Constitution on a regular basis was happening, and the House was not given that information to be able to deal with it. And, you know, maybe there were people who knew things and should have talked to other members of the House about them, and, you know, that's too bad. But I don't know anybody knew, and I don't know who knew what and when. And in other cases, it has usually happened. In other cases, when a member hasn't been living in their district, somebody has made a complaint to us rather than to the Attorney General's office, and the House has undertaken its own investigation, which is what the House ought to be doing. And I just want to make sure that we can get that information as quickly as humanly possible. And as I said, it may be that this is something that we decide is not something we can draft around. And I'm perfectly okay with that. But I think it's a matter that this House ought to take up. And then, you know, people can vote however they feel about the result. If a committee is able to come up with something that they feel is appropriate, then great. And if the committee believes and the House believes that this is inexpedient to legislate, we have a vote for that, which is why I want to see it be considered by the House.
Jim Smith?
Thank you, Mr. Speaker. We're getting way into the weeds of a bill that doesn't exist. The simple question is, as my friend from Walpole said, why she needs late drafting. She did. That satisfies me. This is a conversation that can happen, so, I mean, why not?
I'd move the question. Clerk will call the roll.
The motion is to allow late drafting. Representative Packard,
Yes?
Representative Shirtliff,
Yes.
Representative Smith,
Yes.
Representative Nodder,
No.
Representative Osborne, Representative Sweeney, Representative Wilhelm,
Yes.
Representative Weber, Representative Simpson.
Yes.
Motion is adopted 8-1.
So seeing we've had such a good discussion on this bill, can we vote on it now, or? Yes.
When must I have something to OLS by?
Thank you, Representative. Typically, after this meeting, I go over to OLS and inform them that, that the late draftings have been approved. Usually, we don't have a steadfast rule in this. However, usually we try to do it within a week or so.
Oh, absolutely. Yeah, thank you.
Is there any other business to come before us?
Just to clarify, Mr. Speaker, it does allow for late drafting. The same deadlines, however, for sign-offs do apply. So that's, and just a quick reminder, as we undertook in our spring meeting, the late drafting has already been approved by statutories as well. So they are free to do that.
Representative Smith?
Thank you, Mr. Speaker. So there have been questions in my short tenure in the House of 12 or 13 years about when Part 2, Article 7 of the Constitution applies. That's the one about not taking fees or acting as counsel to advocate for a cause before the legislature. It might interest you to know that over 100 years ago, the House had a rule defining this so that we didn't actually have to fight with each other about what it actually means and whether or not some group paying you a salary to then come here and file bills for them qualifies. I think it does. Some disagree with me. So what I would ask is, this is a solution that has to be of the House and not a political fight. If there is any member of the other party that would work with me on drafting a rule such as this to, the old words from the early 1800s were, be fully explanatory of Article 2, Part 7. Sadly, we don't have that rule anymore, and then it would have applied to lawyers. And then, that was their worst fear then, because they didn't know what lobbyists were, but yet here they are. Sorry, guys. So you don't have to answer now, but it would be great if we could get a bipartisan drafting of when Part 2, Article 7 requires you to forfeit your seat. It's a very short article, and that is the penalty. And I believe I know of at least 3 cases where it was violated. I mean, we don't want to get to the point, right, where the NRA or Planned Parenthood or the New Hampshire Municipal Association or anybody, even if it's a group we like, decides it's a really good business model to pay someone a salary so they can come on in here and file bills and be an inside the house advocate. That should never happen. That's just my opinion. So I would ask you to consider that. Thank you, Mr. Speaker.
Is there any other business to come before us? Move adjournment. Second, all in favor?
Aye.